Good afternoon and welcome. My name is Keith Bybee. I direct the Institute for the Study of Judiciary, Politics, and the Media. And I'm delighted to have you here for this is the fifth lecture, sixth lecture, as I was saying, in our series, Law, Politics, and Media, this spring. Today's lecture is sponsored by IJPM and the Kissel Fund for Civil Liberties. And the Tully Center for Free Speech, which is directed by that young man there, Roy Gutterman. Now, many people will tell you that to know Roy Gutterman is to love Roy Gutterman. But I would add to that, to know Roy Gutterman is to ask, what is that beguiling fragrance? As you know, we bring speakers from the bench, the bar, world of policymaking, and news media to discuss topics that intersect with law, politics, and the media. Today, we're very fortunate to have Ken Armstrong. His lecture is entitled At the Intersection of Journalism Law, How a Reporter Covers Judges, Prosecutors, Defense Attorneys, and Civil Litigators. Ken is a Pulitzer Prize-winning journalist. He worked for the Seattle Times and the Chicago Tribune. He's done a number of investigative series. I've had it's really amazing to read his work. It's extraordinarily thorough and detailed. It's also depressing and enraging. He has really done tremendous service uncovering a lot of wrongdoing within the criminal justice system. He has served as McGraw Professor of Writing at Princeton University, and he's been a Nieman Fellow at Harvard. He currently works for the Marshall Project, which is a nonprofit organization devoted to investigative journalism of the criminal justice system. Marshall Project works appear in a number of different outlets. They partner with different media outlets. He has done work, among others, with This American Life. Let me just remind you a few things about logistics, how we'll proceed. We will have, after Ken's lecture, a period of Q&A. If you have a question, I just ask you to raise your hand. Ken can call on you. These domes that are embedded in the desk are microphones. Just ask that you press the button next to the dome so the green light goes on. That way your voice will be captured on the video recording that we're making. At 5 o'clock, we'll have a reception right here in this room. So if your schedule allows, please do take some time to join us for some food, for some drink, and some continued conversation. Without further ado, please join me in welcoming Ken Armstrong.
Thanks, Keith. And thanks, Roy. And thanks for having me here. This is my first time to Syracuse, and this afternoon I got to take a quick walk around the campus, and I saw one building in particular which made me so happy. And it's going to sound weird, but it was the Maxwell School of Citizenship. It was great. My wife does a lot of work in the field of education, and she's always been bemoaning to me the disappearance of civics courses from high school curricula. And now I can go home and tell her that Syracuse has an entire school devoted to citizenship, which I'd never seen before, and it's awesome. So now she's going to want to send our kids here, I'm sure. I want to start with a quick story that will give you a sense of the work that reporters do, particularly when we're writing about criminal justice. A number of years ago, when I was working at the Seattle Times, I got a tip about problems with the quality of representation being provided by public defenders in Grant County, which is in the middle of Washington State. There were stories circulating about one public defender in particular. So I went out to Grant County and I began looking at court files for cases he had handled. One of the most serious cases he had handled was a 3 strikes case. His client, Andrew Williams, was charged with rape. Williams had 2 prior felony convictions that counted as strikes. So if he was convicted of this charge, that would be a 3rd strike, and he was going to get a sentence of life without parole, mandatory. So short of a death penalty case, the stakes don't get any higher in the criminal justice system. For this case, the clerk's office brought out about 3 banker's boxes stuffed with records. And I settled in and I just began paging through the documents to see what I could find. A lot of the documents were fill-in-the-blank motions, asking for a continuance or whatever. And on one of them, there was something that caught my eye. I'd like to show you that document. It's just a single page, and ask if any of you see what I saw. Is there anything on this document that just doesn't seem right? That's not it. It's interesting, but it's not as interesting as something else on there. Yes. Exactly. Look what kind of testing he wants to do. D and A. This is a rape case. What evidence is going to be more important than the forensic evidence? It's a 3 strikes case. If he's convicted, he's going away to prison for life. And here he is with a public defender who doesn't even know that it's DNA. He thinks it's D and A. If I'm his client, what kind of confidence am I going to have in the quality representation I'm getting?
Doesn't the client have to know about a DNA at that time?
He would have to know that. Chances are he probably never saw this. Right? This was probably a form that his attorney filled out. And I had to check with his attorney. I had to interview him and make sure that that was his handwriting, and he said that it was. But yeah, but the judge would see this. If you're the judge, what kind of confidence are you going to have that the adversarial system is going to work as it's designed to? When the public defender is asking for D&A testing in a felony rape case. Now, all this is, though, is just one example of a certain lack of sophistication. But it was an example that was supported by all kinds of other examples from the same attorney. This attorney told one client that he couldn't appeal, when the client certainly could. He told another client that he could leave the country before trial, when that client most certainly could not. This attorney hadn't won a trial in 7 years. He was 0 for 23 during that stretch, which isn't surprising when you learn about and take into account his lack of preparation. In one murder case, the police, when transcribing his client's tape-recorded statement, inserted damning words into the transcript that his client never said. But this attorney never caught that because he never bothered to listen to his client's tape-recorded statement. But again, what does this mean? Other than the existence of one public defender of questionable competence, he was later disbarred, by the way, who appeared to do little work preparing for trial. Well, this attorney worked in a county where he was not the exception, but the rule. In this county, the public defenders had fixed fee contracts, meaning they were paid the same no matter how many cases they were assigned and no matter how much work they did on each of those cases. These contracts provided a way for the county to control costs, to save money. But the result was the public defenders tended to have way too many cases, and they had a financial disincentive to work those cases hard. They would be paid the same whether they spent 2 hours or 200 hours on a particular case. So in this county, the public defenders tended to represent their indigent clients less than zealously. Tom Earle, who was profiled in one of the stories on the reading list, also worked in this county. And this county was not the exception. It was the rule. In Washington state, 2/3 of the counties had these awful fixed fee contracts for public defense. So we looked at other counties. And in Cowlitz County, which is in southwestern Washington, we found Lisa Tabbitt, a public defender who had a fixed fee contract that paid her $86,000 a year. Now, how much work did she have to do for $86,000? The American Bar Association and the Washington State Bar Association Both had caseload limits that they recommended, saying attorneys couldn't be effective if their caseload was too high. These limits said, for example, that no attorney should have more than 150 felony cases a year, or no more than 250 juvenile cases a year. Well, here's what Lisa Tabbitt's caseload looked like. She had 295 juvenile cases in a year, which by itself, just those 295 juvenile cases, is above the recommended caseload limit. Plus, she had 276 dependency cases. Those are incredibly complicated, demanding cases. And the caseload limits recommend that you only have 60 of those a year, with nothing else. If you're doing nothing else, you only have 60 dependency cases. She had 276. She had 16 appeals, plus 5 adult felonies. You add it all up, and she had 6.5 times the recommended standard. For those $86,000, she was doing the work of 6.5 attorneys. Now, I interviewed her, and she said that her workload was insane. That was her word. And she said that what she was doing was, quote, malpractice per se. Very candid. And ultimately, she wound up resigning her contract because she felt like she couldn't reconcile her ethical obligations as an attorney with what was being demanded of her under the contract. We published the series in 2004. And in 2012, the Washington Supreme Court, while citing our series, imposed caseload limits, putting an end to the kinds of contracts responsible for Lisa Tabbitt's workload and for Tom Earle's workload. You know, if you read the story about Tom Earle, you saw that he had 413 felony cases in 1 year, which was more than double, almost triple the caseload limits. So it took 8 years, but in the end, our reporting had an impact that applied statewide. So in reporting on criminal justice, what we're looking for is not just the example of an attorney who asks for D&A testing. That's just an example. What we're looking for is patterns, context. We're looking for things that speak to a systemic breakdown in need of repair. And this approach, the search for context, for patterns, also applies to reporting on prosecutors. In another story on the reading list, we profiled Scott Arthur, a prosecutor in Cook County, which is where Chicago is located. Arthur repeatedly committed misconduct as a prosecutor, but he wasn't punished for it. Instead, he kept getting promoted. And in this, he wasn't alone. In a separate story in that same series, we wrote about how we found 42 prosecutors in Cook County who had cases reversed based upon a finding of prosecutorial misconduct, but who weren't punished for it. They weren't disciplined. Instead, those 42 prosecutors became judges. In the profile of Scott Arthur, we wrote about Verneal Jimerson, who had been convicted of murder and sentenced to death, only to have the conviction reversed based upon an appellate finding that Arthur, the prosecutor, had allowed his star witness to lie, had knowingly allowed his star witness to lie. And Jimerson was not alone. We did a sweeping search nationally looking for homicide cases where a conviction was reversed because prosecutors had either knowingly presented false evidence or had failed to disclose exculpatory evidence, had committed a Brady violation. That's the most serious kind of misconduct in the eyes of the courts, and that's the most serious of cases, looking at homicide. The U.S. Supreme Court has declared such misconduct to be so reprehensible that it warrants criminal charges and disbarment. Well, we found 381 homicide cases nationally that had been reversed on this basis. And in not one of those cases was a prosecutor convicted of a crime. Not one of those cases was a prosecutor disbarred. We found several who became judges. One was elected to Congress. The list went on and on. They weren't punished. They continued to elevate up through the ranks of the legal profession. So that's a telling pattern. That's a pattern that speaks to a lack of accountability when prosecutors fail to abide by the rules of a fair trial. So how did we find those 381 cases? I should first tell you how I became a reporter. I basically fell into journalism after dropping out of everything else. I wanted to be a lawyer, so I went to law school at the University of Chicago, where I discovered after a year that I really didn't want to be a lawyer. So I dropped out. I went into the Peace Corps in Mauritania, West Africa, where I discovered that I really had nothing to offer. It turns out that developing countries like Mauritania have no burning need for political science majors. It's very sad, I know, but it's true. So since I had no skills, I was assigned to be an agricultural extension agent in the Sahara, even though I couldn't grow a tomato plant in my own backyard. This did not work out well, so I dropped out. At that point, I went into journalism. And this was in the 1980s. In the 1980s, journalism welcomed dropouts. You don't have a journalism degree, you have no particular skills, come on, come aboard. Not the case anymore. These days, it's much more difficult to get started in the field if you don't have basic training or a degree. But in those days, there were all kinds of reporters who had this similar career arc to mine, where they basically flamed out in this direction, that direction, and they just fell into journalism. One thing, though, that I took from my dropout years was that I knew how to use Lexis and Westlaw. And I knew that those databases could be used for more than legal research. They could be used for more than divining the case law on whatever issue you're researching. They could be used for journalistic purposes. So one of the searches that I did when I was looking for these cases with these Brady violations was this. I had all kinds of searches like this that I was using. This particular search, this was in the late 1990s, kicked out 11,000 cases. I then had to go through each of those 11,000 cases online in Lexis to see how many of them fit my criteria. The vast majority did not, but some did. As you can imagine, it was very, very tedious work. And that's a description that applies to a lot of investigative reporting. You tend to see movies like All the President's Men and Spotlight, and it really looks exciting. But boy, a lot of it is this. It's really, really boring. And you just sit in front of that computer for hours on end, days on end, plowing through cases, building numbers. Now, I've been talking a lot about numbers and patterns. And the reason is numbers hold power. An individual case might be dismissed as anecdotal, as perhaps an aberration. But if you can show that an individual case fits a pattern, that's part of a pattern, that's harder to dismiss. After doing the series on prosecutorial misconduct, the next project we worked on at the Chicago Tribune dealt with the death penalty in Illinois. And what we did in that series is we looked at every case where somebody had been sentenced to death in the state since capital punishment's reinstatement. And in Illinois, it was reinstated in 1977, so a year after Gregg. At that time, there were 286 cases. We pulled the files for every one of them, and we created a spreadsheet, an actual hand-drawn spreadsheet, where we started filling in categories. Who was the defense attorney? Who was the prosecutor? Who was the judge? Was the defense attorney appointed or retained? What happened to that defense attorney? Ever disbarred, ever suspended? Things like this. We had all kinds. We were looking at the types of evidence that was used in each of these cases. So we're basically building a hand-drawn spreadsheet. If I had been more sophisticated, I would have used Excel had it been around then. I'm not sure if it was in the late 90s, but it doesn't matter because I'm terrible with spreadsheets, and I probably would have done it by hand-drawn anyway. But what we found by looking at those 286 cases was we came up with all kinds of powerful numbers. We found, for example, that at least 33 times a defendant who was sentenced to die in Illinois was represented at trial by an attorney who has been disbarred or sanctioned. To give you an idea of how egregious this could be, if you look at this example, there was one case where somebody was suspended for incompetence and dishonesty. 10 days later, after he got his law license back, he was appointed to represent a client in a capital case. Illinois has had one attorney in its history to be disbarred twice. He was disbarred, reinstated, disbarred again. In between disbarments, he represented 4 people who were sentenced to death. And in all of those cases, he was appointed by the court. You get the idea. The courts were not particularly concerned about the quality of counsel that they were assigning to people who were in danger of being executed. In at least 46 cases, we found that the prosecution's case was built, at least in part, on the testimony of a jailhouse informant, often called a jailhouse snitch. One of the least reliable forms of evidence you'll find in any criminal proceeding. You'll one where a lot of states have even placed restrictions on them, or they take pains to warn juries about how unreliable this kind of testimony is. We found, go down, 35 instances where a defendant who was sentenced to death row was black, but the jury that determined guilt or innocence was all white. And that didn't happen by mistake. This was an instance where prosecutors were using their peremptory strikes to remove African Americans from the jury pool. There was one case where they removed 20 African Americans from a single jury pool to get an all-white jury. We found other instances, it's not noted here, where they removed 16 African Americans from the jury pool or 11. This was done systematically in Cook County. It's not supposed to happen. It's against the law, according to Batson v. Kentucky, but they were doing it regularly. 2 months after we published this series, the governor of Illinois declared a moratorium on executions. He said that his faith in the system was so shaken that he wasn't going to sign any more death warrants. And when he made that announcement, he cited these numbers. He also cited one particular case that had been investigated by Northwestern journalism students, where an innocent person had come within 2 days of being executed. So he used a powerful example of the system not working, and then he used the patterns that we had turned out in our reporting. So to me, that was almost an ideal example of how a lot of times one powerful example buttressed by system-wide reporting will show people the fault lines that exist in a particular system. Judges. We've done similar reporting with judges where we're looking for patterns. When I started at the Seattle Times, there was something that kept happening in the newsroom, which caught my attention. And that was reporters kept mentioning that they were looking for particular files, court files on their beat, but they weren't able to see the file because it had been sealed. This was happening with business reporters, education reporters, healthcare reporters. There were medical malpractice lawsuits that had been sealed. There were lawsuits against the state social services agency that had been sealed. Lawsuits involving allegations against public school districts and the way principals handle particular cases. These were files involving issues of importance to the public, and yet they were being sealed in their entirety. Well, there are explicit rules that were established by the Washington State Supreme Court governing the sealing of files. So we pulled the sealing order. Well, actually, let me back up. What we wanted to find out was first how often this was happening, because all we had was this anecdotal evidence of reporters talking about this. We decided to see if we could find out how many times lawsuits had been sealed in their entirety. It would have been nice if the clerk's office kept a master file and we could just ask them if they hand it over, but it didn't happen that way. They said we don't keep that information. So a reporter who was a computer-assisted reporting specialist named Justin Mayo, he and I began looking to see if we could discover all of these sealed files. And what we discovered is that all of the electronic dockets are kept in one place by the administrative office of the courts. It's a system called SCOMAS. And they have codes that they use for each thing that happens during the course of a case being litigated. If there's a motion for summary judgment, there's a code for it. If the complaint is filed, there's a code for it. If there's a motion to seal something or a motion for a protective order, there's a code for it. So Justin and I came up with 5 codes that we thought were the strongest indication that maybe a file had been sealed. And then we went to the administrative office of the courts and we asked them to do a system-wide search of all of their electronic dockets looking for these codes. And they agreed to do it, to their credit. I'm not sure that they were legally obligated to, because in effect we were asking them to create a file or a list for us. And a lot of times that falls into a gray area in the public records laws. But they agreed to do it. And the search was so massive, they said that they would run the search overnight because it was going to tax the system. It was going to tax their mainframe so heavily that they didn't want to run that search while they were conducting a normal day's business because they were afraid it was going to crash. So night after night after night, they ran the search for us, and it kicked out so many cases. And then back to this theme of the work being tedious, I went to the courthouse and took this list of all the case numbers and ran them into the public terminal. If the case was sealed, I got a box that popped up saying that I wasn't entitled to see the file. That way, I knew it had been sealed. The clerk's office also let me search in a different way. Again, I don't know if they were legally entitled or required to do this, but they were great. They gave me a pass where I could go back into where the physical files were kept, and they just let me walk all of the aisles. And what I was looking for was yellow slip folders, because if a file had been sealed, another way that they typically accounted for it was they put a yellow slip folder on the shelf where the file should be, which was a way of saying there should be a file here, but it's sealed and it's kept separately behind a locked door that's passcode protected. So I'm walking the aisles while Justin is doing the crafting searches for the mainframe. And at the end, we found that there were 420 baseline, at least 420 civil cases just in King County that had been sealed in their entirety. And files should rarely be sealed in their entirety. The courts are presumed open. You might find cases where particular documents in it are sealed, but not the entire one. So we wanted to see if these were being sealed in accordance with law. So we pulled the sealing orders in each of these cases, and it turns out that they weren't. Under the law in Washington, a judge can only seal a file if they make three specific findings. One, they have to find compelling circumstances. That's a high legal threshold. Instead, what we found is that judges were consistently sealing for good cause. Good cause is a much lower threshold than compelling circumstances. So judges didn't even know what finding that they were supposed to find. This would almost be like the difference between beyond a reasonable doubt and what you would find in civil, like a preponderance of the evidence. Good cause is a very easy hurdle to pass. They're also supposed to weigh the public interest in open courts, and they're supposed to weigh that against the argument for secrecy. They rarely did this. Instead, they would just say why they were sealing it. In this case, one of the litigants was denied right to obtain a security job. That may not be a bad thing, depending upon what's in that file. That may be a good thing. There should be some weighing of the public interest here. There was none. The court was also supposed to explain explicitly and in detail why they were sealing. This is what we often found. One, look how long that line is. How detailed of an explanation are you going to provide when they give you room for, I don't know, if you were to type that out, maybe 10 words, that's probably being generous, but they often just left it blank. So we found that in 97% of these cases, the rules had not been followed. So what we then did is we went to court and we started filing lawsuits to have these opened. And we filed 40 lawsuits, and we prevailed in 38 of those 40. And the other two, I'm confident we would have prevailed had we appealed, but by that time we had already gotten the records through other means, so we didn't really need to. Once we got records opened, we then wrote about what we found inside. So we wrote a lot of individual stories about these cases. And the impact ultimately was, one, that there was some accountability for people we wrote about. For example, I think one of the stories you read concerned principals in an elementary school who were not doing anything in response to complaints about a teacher who was accused of sexually molesting students. The key principal in that wound up resigning after the story came out. He had moved on to one of the state's top high schools where he was then principal. And after he wrote about how he had handled these complaints in elementary school, he stepped down. System-wide, the court stopped sealing records. They were embarrassed. The judges were embarrassed. They knew they hadn't been following the rules. And across the board, they stopped sealing files. Justin and I would check periodically, and for months and even years later, we couldn't find a single new file that had been sealed, which was great. Now, before I run out of time, because I want to make sure we keep time for questions, I wanted to touch on four takeaways for me in writing about criminal justice. And one is that a lot of the problems that we've written about, whether it concerns public defenders or prosecutors or judges, they often seem traceable to a fundamental misinterpretation of a participant's role in the justice system. In one of the stories you read, Tom Earle, the public defender, said his role was not to investigate and find proof of innocence. His role, as he described it, was merely to see that his client's rights were protected. In his description, a public defender is thoroughly passive, reactive, just kind of standing there, waiting to see if there are any fouls that he should whistle. And the job of a public defender encompasses so much more than that. His job is to investigate. His job is to advocate zealously. If there's evidence of innocence, it is his job to go out and find it and prepare it. I found a number of public defenders over the years who tend to minimize what their job entails, and that leads to enormous problems. Prosecutors sometimes lose sight of their role. The duty of a prosecutor is to seek justice, not merely to convict. Last year, a former prosecutor in Louisiana who had put an innocent man on death row spoke for a lot of prosecutors when he wrote very candidly that he had become blinded. He wrote, quote, "I was not as interested in justice as I was in winning. Winning was everything." And the judges who signed all of those sealing orders, several told me they did that because both parties had agreed on it. And signing an agreed order was the easy and efficient thing to do. It moved the docket along. But judges have a responsibility that extends beyond the parties before them. Judges also have a duty that extends to the public, and they can't lose sight of that. A second point, the law profession is self-policing. Lawyers are supposed to regulate one another through the bar or whatever the licensing and disciplinary apparatus is in a particular state. But I found that lawyers also regulate one another in another way, through the media. I'm often tipped to stories about wayward lawyers by other lawyers, lawyers who are just weary, fed up, beyond disillusioned by the problems that they see in their profession. The first story I talked about involving the attorneys in Grant County, Washington, the person who tipped me to that was Peter Neufeld, the co-founder of the Innocence Project, the partner of Barry Scheck. He was out at the University of Washington talking to the law school there, and he and I had lunch afterwards. And Peter has a home out in Eastern Washington, and he was familiar with problems in the court system there. And he told me that it would be worth my while to go out and spend some time looking around there. And it was because he was disgusted at what he had heard and what he was seeing. I consistently find that often the people who stand up and voice strongly their displeasure with what's going on, it's fellow attorneys. From the reading list, you would think that all we write about is attorneys who are failing, who are the worst representatives of the profession. I've written a lot of very positive stories about lawyers, and I can tell you, I really like attorneys. They're some of my very favorite people. For every Tom Earle I've written about, I've spent time with a Steve Bright or a Brian Stevenson or a Larry Marshall. I've written a lot of profiles about people who have done, lawyers who have done the right thing under very difficult, challenging circumstances. Right now, I'm working on a historical story about a prosecutor who did one of the most heroic things I've ever seen. And in fact, Felix Frankfurter, when he was on the faculty at Harvard Law School, wrote to this prosecutor in 1927 and said, "Your handling of this case will go down in the annals as the standard by which prosecutors should be judged." So I want to tell that story because to me, it's worthwhile as a counterpoint and as a reminder that prosecutors have done the right thing. They continue often to do the right thing. At the Marshall Project, we had a first-person account from the prosecutor in Seattle who talked about how he dealt with a wrongful conviction case and how when evidence came to his attention that they may have convicted an innocent man, how he handled it. And it was beautiful the way that he handled it. It was a case where there was no political pressure to release the person. There was no DNA evidence. This wasn't an easy wrongful conviction case. But they took it seriously in every way possible, and they eventually made sure that the person was not only released from prison, but got compensation from the legislature for being wrongly convicted. The last point I want to make, and then I want to make sure there's time for questions, is finding these patterns, generating these numbers takes a lot of time, and it often takes a lot of money. One of these series took 8 months to do, another took 11 months, one took nearly 2 years. And they're expensive. The Lexis search that I showed you, this was in the late 90s, but we got a 3-month contract from Lexis that allowed me to do unlimited searching within the database. That cost $18,000 just for a 3-month contract. Now, most newsrooms have Lexis availability across the newsroom, but they're expensive. You may not know that here. I'm sure that in the law school, you have free access to Lexis and Westlaw. Once you get outside of school, it becomes one of the biggest expenses. And it's jaw-dropping how expensive it is. The lawsuits that we filed to get those sealed files opened cost us $200,000 in legal fees. And these were not ones where the court ordered, even though we won in 38 out of those 40 cases, we did not get our legal fees. We had to absorb that. That project was done in 2006, 2 years before the economy cratered. I can't imagine too many newsrooms these days that would pay $200,000 for a project like that. And when I think about journalism and its future, I'm not as pessimistic as many people in the field. If I were young again, and if I was interested in a journalism career, I'd launch in enthusiastically. I actually have great hope for journalism. In fact, I think there's so many advantages to doing journalism today as opposed to 30 years ago. But the one thing I really, really worry about is resources and whether newspapers or other media will be willing or able to spend the kind of money that it sometimes takes to do this kind of work. That's it. So I'm going to leave time for questions. Okay.
Hi, I just have a very simple question, primarily because we were trying to define this term altogether, and as it is something that you do, you'd be better able to define it for us. Could you tell us what do you think, or what by virtue of what you do is investigative journalism?
Yeah, I knew you were going to ask that because Shannon was saying that was a conversation in the class. I don't define it. And the reason I don't is I tend to subscribe to a theory that's often expressed that all reporting is investigative. But what's odd about that is that on our website, I think I'm described as an investigative reporter. I kind of wish that I wasn't, because it has two impacts when people see it. One, if they feel like they've been wronged and they want someone who's going to pursue their story, if they see investigative reporter, they think, oh, that's the person. That's who I need to reach out to. They're wrong. If you just see a reporter, generally they should reach out to it. The other thing it does is it gives the misimpression that I'm out to write only critical stories. And I think a lot of people, when they see the title investigative reporter, they get a misconception about what my approach is to a particular story. And I like to think that I'm open-minded and that I'm really eager to hear what people have to say. But the main reason I don't define it is every definition I've ever heard I found unsatisfying. I just think reporting in general is investigative. Like one definition you hear is that it's breaking or disclosing something that someone wants to keep secret. Well, a lot of times you're writing about system failures. Like when we wrote about the death penalty, who was it that wanted to keep that secret? I would be really hard-pressed to point to one individual in Illinois who was determined that we not find the fault lines that we did. It seems to me to minimize it too much. And so I'm of no help with that question, which is a really bad sign with the first question. But I think all reporting is investigative in its own way. So I tend to think it's a false divide. In newsrooms, when they have an investigative unit, it usually means they have more time to work on stories. They don't have a beat where they're expected to follow incremental developments on individual stories. They're freed up to spend those 8 months or those 11 months or those 2 years to do the work. So the most practical difference is that you have the luxury of resources and time. Yeah.
You ended your remarks with exactly what I wanted to ask you about, which is, given the expense and time that's often involved in investigative reporting, how do we keep that going? How do you convince a newspaper or magazine that that's something that's essential? I'll just throw out one possibility. Is it joining forces, maybe a couple publications or reporters from different outlets working together on a story, or is that impractical?
That's not impractical at all. In fact, that's becoming more and more sought after. One of the stories, an unbelievable story of rape, that was a collaboration among 3 nonprofits, right? It was a collaboration between the Marshall Project and ProPublica and This American Life. None of us have advertising, right? We all rely upon donations to keep us going. But we pooled resources to do that story. And one of the arguments that you make for funding that kind of work is that people read it. That's the story that we ran on our websites was 12,000 words long. That's an exceptionally long story by print standards. And it was easily the most read story in the history of the Marshall Project and in the history of ProPublica. Independently, you add it together, the numbers were crazy high. Then you throw in This American Life, they get about 2.3 million people who download the podcast each week. They have another 1 million plus people who listen to it on the radio in like 500 stations around the country. So it was a story that had very broad reach. It took a long time to do. It was a lot of work, but people will read investigative stories. They will read long narratives. And, to me, so you have the element, one, it can be impactful. It can make a difference in how people see things and how it might lead to a difference in laws or regulations or whatever the case might be. But I think that's what you're going to see more and more is you're going to see regional versions of ProPublica. You're already seeing that. You have investigative nonprofits in particular states. You have some that are defined regionally, like Investigate West. There's probably going to become too many of them because there aren't enough charitable donations to go around. But I think the Marshall Project is like an example of what you're starting to see, where you have a nonprofit that is devoted to one specific area of coverage. Us, it's just criminal justice. You have climate change, which just looks at environmental issues and does excellent reporting. You're going to see, I think, specialization among nonprofits. And you are going to see more pooling of resources. Like This American Life paid for my reporting expenses on that story. So what they got was free. They got free labor from me as long as they paid my way to go to Colorado and to go interview Marie and to go to the different places that we had to go to. So it used to be that competition was the driving force in everything that we did. Now people are eager to collaborate instead of compete. And since I've started at the Marshall Project, I've had stories that have run in the Washington Post, the Paris Review. Paris Review, that's a very odd one. Wired Magazine, Mother Jones, all kinds of different places. And again, what they get is they get free content from us, and then we get access to their readership because our website has very low readership. We're new, we're a startup, so we need to reach a broader audience than what we can through the marshallproject.org. And the way we do that is by partnering with people who already have established audiences.
So you mentioned that your article, the one that you partnered with This American Life and ProPublica, was exceptionally long by print standards, but then you adapted it for the radio. And I know you mentioned during the lunch that there were some problems with interviewing like the crying woman and things like that. But do you feel like in general you lost anything translating a long print story into a 58-minute piece for This American Life?
We didn't have as much context in the radio piece about the limitations of rape investigations and a lot of statistics that we had in the print piece that provided context. There just wasn't space within that hour. The radio piece, I think, became much more relatable to people. And what we found is that listeners had a more visceral reaction to the radio piece than they did to the print piece. There was something about hearing the voices instead of reading their words in between quotation marks. And the radio piece, they just have a different approach. But I think it was fully compatible with the print piece. In fact, I think the print piece and the radio piece worked best together. Like if you read the print piece and you were still interested in hearing what does Marie sound like, we had one audio snippet in the print piece, but it was very brief. You listen to the radio piece and she comes alive in a way that she doesn't in the print piece. When you actually hear her voice, it's a totally different experience. When you hear the foster mothers, it's a different experience. When you hear the police officer, the lead detective in Linwood, who made the awful mistake here, right, and decided that she should be charged with filing a false police report, when you hear him talking about it, I don't think there's any question that his remorse is genuine. And sitting in that room with him, it was. I mean, he was really struggling to control his emotions. He was shattered by the mistake that he had made. In print, it's very hard to convey that because the words become very static when they're just written and they're on the page. But when you hear the long pauses and you hear the catch in his voice, it's different. So yeah, I think that there were things that each lacked that the other had, but that's just the differences in the media. Yeah.
I bet it took 6 months of going back and forth between Marie and before she would talk to you. So, for when you're doing investigative pieces, what are some methods you use to convince people who might be skeptical to speak with you?
Yeah, she had never spoken publicly about what had happened to her. And you can certainly understand why, right? She had been victimized 2 times over. She had been hurt in the worst way imaginable, and then she wasn't believed, and then she was hurt again by the police. What I did is I approached her through her attorney. And what I do is I try not to reach out to people when they're at their most vulnerable. What I do is I have a file, which I call my call later file. And whenever I see a breaking news story where I'm really interested in hearing what somebody experienced and what they went through, but I know that they're being besieged by other reporters. And I know that they're in a raw state right now where probably the last thing you want to do is talk to a reporter. I wait. I put it in my call later file, and I let 6 months pass or a year pass. And I call them when the storm has cleared, and maybe they've thought back about on what happened, and maybe they're reflective. Often when people have made mistakes, that's when I'll wait, because I find that people are often remorseful and reflective if you give them time. So that's the first thing is I do. Whether somebody's been hurt or whether they hurt someone else, I give it time. Then what I do is I just try to explain to people how the media works and how sharing their experience with the public might have a benefit to other people. In Marie's case, she understood. I wrote her 3 very long emails that I passed to the attorney telling her, this is what the Marshall Project does. Here's the work that I've done in the past, and here's some of the impact that it's had. Here's what This American Life does. Because This American Life has a huge audience, and they've had incredible impact with their reporting. I mean, the people who listen to This American Life include the people in the White House, right? You have Michelle Obama, who goes out to a high school that they do a story on, to visit in person. You really have an opportunity to reach a lot of people and change the way people see things if you're involved in something like that. So I just try to be as open and candid as I can about why I think it would benefit people to share their story. And then I let them ask me questions first. I never go meet somebody with a notebook or a microphone out. And my first meeting is almost always, if it's a tough one, it's like, look, I just want to sit down, have coffee, ask me whatever you want. I'll try to explain what we're doing as best I can. And then later, if you agree to do this, then we'll record it. So you really have to be slow and sensitive to their wariness. It took me 7 months in all to get Marie to agree to talk. And that's the case with a lot of this type of reporting. You really need to be patient and perseverant without being insensitive. Yeah.
Thank you for coming here.
Thanks.
I was practicing in Illinois when your stories broke, and it really did change the legal landscape there. When I teach criminal procedure here and we talk about prosecutorial ethics, I assign your article from the Chicago Tribune that you referenced here. It really has been pretty amazing, the impact of that series of reporting. My question for you was about, you mentioned in passing that part of what motivated the change in Illinois was the story of Anthony Porter,
right,
who came within 2 days of execution. And his story is sort of fascinating. I've spoken about it to even undergraduate students because as initially understood, it really was a remarkable story of what 4 undergraduate students could do in an investigative journalism class. But over the last couple of years, we've learned much more disturbing things about the other aspects of this case. So I was just wondering whether you might be able to reflect on the dangers of using a case like that as a narrative, the dangers of relying on other people who may have done some investigation.
Right, and we didn't rely on their investigation for a lot of those reasons. The work that the Northwestern journalism students did was entirely independent of the work that we were doing. We didn't know what they were doing. They didn't know what we were doing. We weren't sharing resources. They were doing it through the investigative reporting class done by Dave Protus, and they had success with the Ford Heights 4 before this. And that was a clear-cut case, right, where it was evident to just about everybody except for the original prosecutor that the 4 people who had been convicted were innocent. They were excluded by DNA evidence. The entire case collapsed. Anthony Porter became so much more problematic. I never wrote about Anthony Porter, and I'm very grateful for that because it is so murky now. Anthony Porter was freed from death row and pardoned, by Governor Ryan based on innocence. And then years later, this was like 2 years ago, maybe? You know better than me. But the current state's attorney in Cook County, Anita Alvarez, they conducted an investigation, and they found a lot of things in the way Dave Protas's class conducted investigations that were very problematic to their mind and cast doubt upon the work that they were doing. And what they also did was there was somebody who was convicted of the same double homicide that Anthony Porter had been convicted of, All-Story Simon, who had been convicted afterwards based upon a confession that he had made to a private investigator who was working with the students. The state's attorney decided that the evidence in that case was no longer credible and fallen apart. So she moved to have the charges, the conviction against him, released. So you now have a double homicide that occurred in Chicago in the 1980s, I think it was 1982, where you have two different people who were convicted of it in separate proceedings decades apart, who have now both been cleared and formally declared, well, neither of them is formally, stands convicted of the crime. It's one of the strangest, most confounding cases I've ever seen. And all that happened after I had left Chicago. But that is one reason why I think there is danger in using one case to speak for a system. Because some cases are aberrations, or some cases are murkier than they appear. And one of the things that always struck me about the work that Dave Protas's class did was it seemed to me that if they were in a legal setting as opposed to a journalistic setting, there would have been less cause for concern. But when they were doing their investigations, they were doing some things that we as journalists cannot do, should not do. And one of those things is deception. In the Fort Heights 4 case, for example, they were working with a private investigator who went to a witness in the case and pretended to be the movie producer, Jerry Bruckheimer, and came with a sharkskin suit, a wad of money, large wad of money, and said, Hollywood's really interested in making a movie about this case. And if you'll tell us the truth about what happened, we'll pay you for the rights to your story. We can't do that as journalists for reasons I probably don't need to go into detail about. But here you had journalism students who were doing that, and they were even open about it. Dave Protas and Rob Warden wrote a book where they recounted that scene in it. And it seemed to me like if they were in a law clinic, there might be different rules that apply to even that would be problematic in a law clinic, I think. But it was the issue of they're really crossing lines, journalism lines, that we consider to be pretty precious. But that said, in that instance, they got the right result. They helped free 4 innocent people, including 2 who had been on death row. It was amazing work. The Anthony Porter case is much grayer. It's just, I don't have any personal insight into who actually committed that crime.
We are actually out of time.
Okay.
So I would like to thank you